Hi, hello, how are you all? Welcome to my channel Law Made Simple with me Vidya Reddy. Today, let us learn about unfair labor practices. Unfair labor practices on the part of workmen and on the part of employer as well. What are the practices which are illegal and it should be abolished? So, let us get into the introduction. Originally, unfair labor practice was not provided in Industrial Disputes Act 1947. A new schedule has been amended and it was added in 1982. Schedule 5 of the Act contains a list of such practices as treated unfair on the part of employers or their trade unions or on the part of workmen and their trade unions. So it is difficult to define and lay down what are the unfair labor practices. It may be said that any practice which violates the directive principles of state policy which is contained in Article 43 of the Indian Constitution and any other such articles as deal with the decent wages and the living conditions of workmen amount to unfair practice. So, National Commission on Labour in the year 1969 recommended that the law should enumerate various unfair labour practices on the part of employers and on the part of workers, unions, and provide first suitable penalties for committing such practices. Accordingly, now we have the provisions for prohibition of unfair labor practice. So, the prohibition of unfair labor practice is there in section 25T of the Industrial Disputes Act 1947. No employer or workman or a trade union shall commit any unfair labor practice. Let us look into the penalty for committing unfair labor practice. Any person who commits any unfair labor practice shall be punished with an imprisonment for a term which may extend to 6 months or with a fine which may be 1,000 rupees or sometimes both. Let us look into what are the unfair labor practices done by the employers on the workmen. Number 1. To interfere with, restrain from or coerce workmen in the exercise of their right to organize, form, join or assist a trade union. So the employer now he will threaten the workman with discharge of his job or dismissal of his job if they join or assist in trade union, and he sometimes threatens a lockout or closure if the trade union is organized. He will grant wage increase to workmen at certain crucial periods with a view to undermine the efforts of trade union organization. So the trade union organization is working day and night to improve the working conditions, and the wages are granted only for those workmen who have the employer trade union. The second one is to dominate, interfere or contribute support, financial or otherwise to trade unions, such as the employer taking active interest in organizing trade union of his workmen, employer showing partiality to certain union. Here the employer has formed his own trade union, and who are the workers, they are getting partiality over the other. The third one is to establish employer-sponsored trade union of workmen to discharge or dismiss workmen by way of victimization or falsely implicating workmen in criminal case, discharging or dismissing a workman because he urged other workmen to join or organize a trade union. Discharging or dismissing a workman for taking part in a legal strike, discharging office bearers or active members of the trade union on account of their trade union activities, changing seniority rating of workmen because of trade union activities, to abolish the work of a regular nature being done by workmen and to give such work to contractors as a measure of breaking the strike, to transfer workmen malified from one place to another under the guise of following management policy, failure to implement award, settlement or agreement, to indulge in acts of force or violence, to refuse to bargain collectively in good faith with the recognized trade union, proposing or continuing a lockout deemed to be illegal under the Act of Industrial Disputes Act 1947, to recruit workmen during a strike which is not an illegal. When there is a strike, there should not be any recruitment. All these things which are illegal and which are against the policy of directive principles of state policy, all these activities are unfair labor practice by the employers towards the workmen. Now let us look at into the unfair labor practices by the workmen or trade unions on employers. To advise or actively support or instigate any strike deemed to be illegal. To coerce workmen in the exercise of their right to self-organize or to join trade union or refrain from joining any trade union. For a recognized union to refuse to bargain collectively in good faith with the employer. To indulge in coercive activities against certification of a bargaining representative. Geraw of any members of the managerial staff to stage demonstrations at the residence of the employers of the managerial staff, to indulge in the acts of force or violence, to hold out threats of intimidation against any workman with the view to prevent him from attending work, to incite or indulge in willful damage to employers' property connected with the industry. So, these are the unfair practices which are done by the workmen or the trade unions, taking the support of the trade unions towards the employer. They can sit and discuss calmly. So these unfair labor practices have got some penalty, and these unfair labor practices should be abolished for a fair and amicable working conditions.